Well, good afternoon, Michiganders. It is Tuesday, February 8th, 2022, and of course, this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. As always, I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and an ambassador for all things good in this great state of Michigan. Welcome to today's program. Just a brief recap. Last week's episode was about pre-hospice care. Pre-hospice care, a service that just might keep you out of the hospital. If you're looking at a loved one who has some significant health issues, might not be ready for hospice yet, but your medical insurance company or your local provider might actually offer you a service that's known as pre-hospice care. Today's episode, something that Amanda and I run into very frequently in putting together estate plans for clients, are oftentimes too late when we're looking at settling an estate, and that is the question, doesn't my will or trust override a beneficiary designation? But please remember, what I'm about to discuss during the program, as always, is for educational purposes only. This is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. So again, the question today, doesn't my will or trust override a beneficiary designation? Well, let's just start with the basics. A will. Written document indicates primarily where you want your estate to go at the time of your death. A couple important considerations about that will, though. One, that will is meaningless until two things happen, or quite frankly, three things would happen. One, you die. Meaning a will is of no importance or no effect until you actually die. Number two, it's meaningless until a probate estate is actually opened. If you never have to open a probate estate up, that will is a meaningless document. And number three, some asset has to pass through probate. So again, meaningless until you die, a probate estate is opened, and an asset passes through probate. Let's contrast that with a beneficiary designation. For example, a beneficiary designation on a life insurance policy. What is that? Well, essentially, that beneficiary designation on your life insurance policy is a contract between you and the insurance company. You have a contract with the insurance company that essentially says, upon my death, X dollars is going to be paid, and to whom is that going to be paid? It will be paid to the beneficiary that I have designated in my life insurance contract with the insurance company. So what happens? Upon your death, once documentation is provided to the insurance company that you have died, that payment is now going to go directly to the beneficiary. It doesn't go through probate. That's really part of the reason that you have a beneficiary designation on there, is so that the asset doesn't have to go through probate. So think about that. A will doesn't control anything until you have assets going through probate. It's only going to control the assets that actually then go through probate. Well, that life insurance policy that is going directly from the insurance company to the beneficiary is not going through probate, which means what? That beneficiary designation is not going to have a thing to do with what your will says. So let's use an example. Let's say I have 2 children. And in my life insurance, I say I want my life insurance policy to go to one of my children. But I have a will. And in my will, I say I want my entire estate to be divided between both of my children. I die. Is that life insurance policy going to be controlled by the beneficiary designation and go to the one child? Or is it going to be controlled by my will and go to the 2 children? The answer is the first. It will be controlled by the beneficiary designation and go to the one child, which means what? My will does not override that beneficiary designation. Other examples, bank accounts, very common today. Clients are going to use beneficiary designations on bank accounts. Same situation. Which is going to control the beneficiary designation on my bank account or my will? Again, beneficiary designation on your bank account is what is going to control. So wherever you have beneficiaries designated, maybe it's on an annuity, maybe it's on your IRA, maybe it's on investment accounts, all kinds of assets that we can have beneficiary designations on, you need to understand that the will that you have is not going to override those beneficiary designations. Another situation that we oftentimes run ourselves into, and that is a conflict between joint ownership of an asset and a will. Again, use my 2 children as my example. I have a house. My will, we've already indicated, says that I want my estate to go to my 2 children, but I have my house jointly owned with one of my children. I die. Who is the house going to go to? The one child that jointly owns a home with me, or the 2 children, as my will says? Again, because the ownership keeps the asset from going through probate, joint ownership is going to control. My one child is going to own the house, not both of my children. Bank accounts. Many clients are going to put a child as an owner on their bank account. So let's say I do that. I've got my 2 children. I put one of my children on my bank account as a joint owner. I die. Who owns the account? My one child, or does my will control? Again, that ownership is going to control, and my one child is now going to own my bank account. We can have that same conflict with all kinds of other assets that are going to be owned. Maybe I've got an investment account that's jointly owned with somebody else. Maybe I've got some U.S. savings bonds that either have designated successors on them or joint owners on them. Wherever it is that you have a beneficiary on an asset or a joint owner on an asset, that is going to control where that asset goes at the time of your death. Not unusual at all to find clients coming in that might have several children, and they've made maybe the oldest the joint owner on everything. Maybe they've made the oldest the beneficiary on everything, and the reason they've done that is they think, well, my will says everything goes equally to my children, so when I die, my one child who receives the bank account has to give it to their siblings. No, it is owned by that one child. They don't have the legal obligation to share that bank account with their siblings. They don't have the legal obligation to sell the real estate and divide it up between their siblings. They don't have the obligation to take the assets that are in that investment account or in that IRA or your 401k and divide it with their siblings because it is theirs. That will is not controlling what is going to happen with that asset. And in fact, and I've talked about this on other episodes, think about this. If they do, let's say my one child receives the investment account, and then turns around and divides that investment account between the other children. That is a gift. From whom? From my one child to the other child or children. It is not an inheritance to the other children, which means now that one child, even if they want to do what I thought they would do, which is divide it up, they have some potential gift tax considerations that have to be factored into. So it's not an inheritance if my one child receives the asset and maybe sells the home or cashes out the investment and divides it up between the other siblings. So the answer, doesn't my will override a beneficiary designation? No. As long as the beneficiary survives you. Now, if a beneficiary dies before you, let's say I put my one child on as the beneficiary and I don't have an alternate, and that child dies before me, now I don't have a beneficiary. It might be I don't have a beneficiary on an IRA if my beneficiary died before me. It might be I don't have a beneficiary on my bank account if the beneficiary died before me, or maybe I never even put a beneficiary on. In that case, the asset is going to pass according to the will. But when I have a beneficiary designation, sometimes, and in different assets, you have to be careful. Some assets, it's going to be a beneficiary. Some assets, it's going to be what we call a TOD, which is a transfer on death. It might be a POD, which is payable on death, but they all essentially mean the same thing. My will is not going to override that beneficiary designation. So the question, what about a trust? If I have a trust, and in my trust I say, I want my estate to go to my two children, and yet I have my one child as the beneficiary on that life insurance, what is going to control? Again, the beneficiary designation is going to control, or that joint ownership is going to control, or that POD or that TOD is going to control. So again, a trust does not override a beneficiary designation. And why is that important? Well, think about it. When you sit down to put together your estate plan, one of the things that we're going to talk to you about is, do you have beneficiary designations? Do you have joint ownership with other people? We need to know that, because if, for example, you say to me, I want my estate to go to my 5 kids, but I have one child as the beneficiary, that needs to be changed. If I want my estate to go to my 5 kids, but I jointly own my home with one of my children, but I want the home to be sold and go to all 5 kids, that needs to be changed. So part of that estate planning process is to look at the beneficiary designations that you already have in place and look at what changes are going to need to be made to those beneficiary designations so your estate planning goals will be accomplished. And one of the reasons I think that I talk about in some of the seminars that we do about having parts without a plan. For example, you go to a bank and open up a new bank account, and very often the bank or the credit union is going to say, would you like to put a beneficiary on that account? Or you're working with your financial advisor, would you like to put a beneficiary on that account? Or you need to have beneficiary on your IRA, 401ks, excuse me. What you need to understand is that those beneficiary designations control where the assets go. So you need to evaluate those beneficiary designations and make sure they match up with what you want to have happen with your estate plan. Again, will is not going to preempt the beneficiary designation. Trust is not going to preempt it. So if there's a conflict after your death between what your will says and the beneficiary designation, or what your trust says and the beneficiary designation, or the joint ownership that you've got, understand what is going to control where those assets go to, which again emphasizes the importance of having a plan before you put beneficiaries on your accounts. The reason to put beneficiaries on your accounts shouldn't be because the bank told me I need to do that. Shouldn't be because my financial advisor suggested I do that. Shouldn't be because my friends told me that I should put my child on as an owner of my home. It should be because it fits with your estate plan and the estate planning goals that you have. So make sure when you're evaluating and putting together your estate plan, you look at those beneficiary designations, and decisions have to be made about possibly changing those. And obviously, if Amanda and I would have the opportunity to be assistants to you in putting together your estate plan, we would be talking to you about those beneficiary designations and what changes need to be made to avoid those conflicts. And of course, Amanda and I would be honored to have the opportunity to help you put together your estate plan as well. So if you don't have an estate plan currently in place, we'd be happy to work with you in putting that estate plan together. If you have an estate plan in place, perhaps you're looking at amending it, we can look at helping you with that. Or of course, we can also assist you in settling a loved one's estate. And unfortunately, again, because of COVID, I know COVID, and it drags on and on and on, but it's still here. It is still with us. People are still dying from it, and we still are concerned about protecting our clients and protecting ourselves and our families. We are still only providing services through our virtual office. That's at doylelawpc.com. If you're a prospective client, go to doylelawpc.com and you will see under the virtual office how it is that we can help put together your estate plan or amend a plan that you already have or assist you in settling the estate. Existing clients, again, go to the virtual office. We have our Update My Plan service where you can request updates to your plans. You can schedule consultations with us to discuss your plan and what changes that you might want to make to that plan. And for everybody that's out there, we have at Doyle Law PC our legal store where you can actually order online without having to come see us certain individual documents such as certificates of trust. So again, that information is all going to be available to you at doylelawpc.com. And I think that's going to be it for today's show. As always, though, if you have a comment about the program, a topic that you'd like to have me discuss, or questions that you'd like to have answered, send me an email, tom@tuesdaywithtom.com, or record what your question is and email me the recording. Send me the recording, and I'll know obviously listen to the voice recording that you have, but either an email or a recording. Let me know what questions you have or what topics you might want to discuss. Or you can always send me a postcard at Tom Doyle, P.O. Box 16066, Lansing, Michigan, 48901. And as always, we invite you, please follow us on Facebook and Twitter. That's going to be Tuesday with Tom. Follow the office as well, Doyle Law PC, again on Facebook and Twitter. And as far as listening to the podcast, the program is available on Apple Podcasts, Spotify, Google Podcasts, iHeartRadio, Spreaker. It's probably available wherever it is that you listen to podcasts or that your friends and family listen to podcasts, so they can likely find it on those services as well. And again, you can always ask your smart speaker to play Tuesday with Tom. Well, thank you again for spending some of your Tuesday afternoon with us today. As always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.